All companies and rigs drilling new wells over 500 feet also universally present an imminent danger. So, I mean, when you're going into some kind of a moratorium, is this a little bit like a temporary restraining order?
Well, what it is that they're actually asking for an injunction to stop the requests for the moratorium. So, but anyway, we're at this point, the moratorium's not in place, and I think what we all have to learn on this is that we have to look further than just what we read. We have to look further than just what we hear. We have to understand that a disaster like this has to be dealt with and continued.
Okay, well, there was one thing that kind of brings to mind an old Russian joke on this kind of thing.
And what's that, Mark?
And that this guy got a job with the government, and he said, well, Vlad, how's your new government job?
And how is his job?
Vlad says, well, I don't have to do anything, but the competition's killing me.
Okay. On that, Mark, I think we're going to move on to our second subject tonight. And that subject is something that's fresh from the news. And that is the incident at the Oakland BART station on New Year's Eve of 2009. And in that incident, we had an unfortunate shooting. But there's much more to the story than just a shooting, a verdict, and the uproar from the people that are related to the victim and the police that were involved.
Well, I understand this is very controversial. I mean, up in San Francisco, I have an office in San Francisco. I mean, this is a topic of conversation, but just is widely controversial. Now, kind of set the scene. I mean, was there a lot of people involved in this altercation, in this situation? Was just one person with an officer? What was the situation anyway?
Well, actually, this is a New Year's Eve event, and what was happening was BART was coming back from San Francisco, and there was a huge New Year's Eve party at the Embarcadero. And the people that were coming back on the BART, they were heading for the Fruitville station in Hayward. And there was 10 to 15 people, and they had, the BART police in Oakland had heard that there was an issue. So they had passed the word throughout the BART line that there was a group of 10 to 15 people that were causing commotion in the first BART train. And so when it reached the Fruitville station, the BART police had an extensive cadre of BART officers willing and ready to go in and break up the altercations.
Okay, so how many people were involved in these altercations? You're talking about a whole BART car full of people. Is this like a melee or a riot, or a few people scuffling? What's
well,
the
they
deal?
say there was 10 to 15 people involved, and it was in the front car. The BART train was filled because BART had been running a late train that night, specifically for the New Year's Eve revelers, as they came back from San Francisco. And so there was one car that there was a lot of commotion going on, and when the BART police approached the train, they could see it from the outside, and they went in immediately trying to make arrests, break up the disturbance. And there were several people that were brought out of the BART train. And one of those was a gentleman named Oscar Grant III. He was a young man. He had suffered some past run-ins with the law, but as far as it was concerned that night, it looks like he was just at the wrong place at the wrong time with the wrong group of people. And as he was brought out to the BART platform, a BART officer, a gentleman named Johannes Messerle, had taken him into, he was trying to take him into custody to calm him down, and it seems as though there was 3 or 4 people that were the center of the commotion or were potentially involved with the commotion. And when Officer Messerle had Mr. Grant on the BART platform, he felt that he was resisting arrest.
Okay, in this kind of situation, if there's several people resisting now, was the BART officer on his own? Did he have fellow officers near him? I mean, how isolated was the officer?
No, he wasn't isolated at all. In fact, he had a partner that was right with him, right next to him. And then they also had a series of other BART officers that were handling the other people that were involved in the commotion. Now, there wasn't just the people in the commotion. There was many, many witnesses on the train. So there was people watching, and there was all the violence was going on. There was a crowd chanting, and the BART officers, quotes from multiple BART officers, stated very clearly that this was one of the most scary experiences they'd ever seen on a BART train.
So what was the crowd chanting?
They were intimidating the officers, profanities, and we're not talking about the people they were taking into custody. We're talking about the witnesses.
So the bystanders were basically showing their support by chanting and saying things for the people that are about to be arrested.
Yes, and they far outnumbered the BART officers. And what happened after that is, once again, there's conflicting testimony from both BART officers and witnesses, and even conflicting testimony between witnesses.
But wasn't there a video of this?
Yeah, there was many cell phone videos taken at the same time. Now, the BART police actually confiscated over a dozen cell phones from people so they could find out exactly what had happened. But all reports from the BART officers indicated that Officer Meserle had Mr. Grant down on the ground and was trying to handcuff him. Now,
was he face down on the ground?
He was face down on the ground.
Okay.
But Mr. Grant had his right hand in front of him and wouldn't give it back, put it behind his back, as Officer Meserle was asking him to do.
Uh-huh.
And so at that point, Officer Meserle had stated to his partner, "I'm going to have to tase this. I'm going to have to tase him."
Okay, now this Officer Meserle, did he have a history of abuse or improper arrest or anything like that, to your knowledge?
No history at all. In fact, he had been an exemplary BART officer with even prior to being a BART officer, no
police brutality charges against him by other arrestees?
None at all.
Okay.
So what happened next was that as he was reaching to grab his taser, unfortunately he grabbed his Sig Sauer handgun and fired once, thinking that he was using his taser, allegedly believing he was using his taser. And unfortunately the bullet went through the shoulder of Mr. Grant. And it wasn't the shot going through that killed Mr. Grant. It was a ricochet
off the BART floor.
Off the BART floor that came back and actually punctured his lung. But that's caused the ultimate death.
But that wasn't the assertion of the prosecutor. The Oakland prosecutor didn't think it was accidental, did he?
No. In fact, the Oakland prosecutor, within literally 48 hours, said he was going to charge him with first-degree murder, which is a high level of intent, and that it was obvious that it was a premeditated shooting. Now,
okay, well, what do we have to do? Let's define first-degree murder. If you're murder in the first degree, what do you have to have? You have to have a homicide. You have to one person killing another person.
That's
right?
correct, and you have to have malice aforethought, which is developed through a premeditative state of mind at the time you're planning to potentially kill somebody. So it rises above all other types of death and homicide.
But wouldn't just the use of a firearm, that's a deadly weapon, couldn't that be considered intent?
No, not at all. In fact, the use of a firearm can go through the whole range of mens rea. And mens rea is the mental thought that you have to pull a trigger and to be found guilty of the varying degrees. Now, we have first degree, we have second degree, and we have manslaughter. And manslaughter can be broken into involuntary manslaughter and voluntary manslaughter.
Okay, so what you're saying, if a jury is going to get a jury instruction on intent, the fact that a pistol was used or a firearm was used is not enough to establish intent. You would also have some kind of planning ahead of time to say, look, I intend to shoot this person, and this pistol is the weapon of choice I'm going to use, and it's got to be, you got to show some premeditation, some mens rea. Okay, so what about if we knock that down to second-degree murder? Let's talk about second-degree murder.
Well, second-degree murder is a lesser amount of intent. It means that there's still an intent to do the crime, but it's not so much that you've spent a longer period of time thinking about it. You're not developing the same level of malice that you would do for a first-degree homicide.
But isn't the classic second-degree murder mitigation would be a husband finds his wife in bed with another man, and then in that fit of rage, he shoots...
Yeah, he has the intent to pull the trigger, and he has the intent to kill somebody, but he doesn't have the premeditation necessary to get to the first-degree murder.
So he was so upset, so angry that he wasn't thinking clearly, basically what you're saying.
That's correct. And part of the problem was all the activity that was going on at the exact moment that when he reached back and hoping to grab his taser, allegedly hoping to grab his taser, he grabbed his firearm instead. Now, unfortunately, the witnesses were so conflicted on the stand during the trial that as a result of that, the jury only had the testimony of what they heard. And it was difficult because Officer Meserly had never met Mr. Grant before. Officer Meserly had never had an incident involving a firearm before. And so to believe that somehow or another he intended to grab his firearm and shoot Mr. Meserly, the jury couldn't find that there was a second-degree murder or that there was even a voluntary manslaughter, and they came up with the ruling of an involuntary manslaughter.
Well, let's talk a little bit about a voluntary manslaughter. For voluntary manslaughter, what would be our intent requirements?
Well, you still need an intent. It means you're intending to do something, but it's not the same intent that you would have for a second-degree murder, because a second-degree murder rises to a different level.
Okay, so in your voluntary manslaughter, would that include something like a bar fight where you had a unreasonable belief that maybe this person could overpower you and then you shoot them? So it would be kind of like an incomplete self-defense or something like that?
That's correct. In fact, you intended to do some harm,
right?
And it resulted in a homicide.
Okay, now what about if someone was on a freeway overpass and they threw a brick off the freeway overpass? They didn't intend to hurt anybody, but that came down, went through someone's windshield, and that person crashed their car and died. Where would that put you?
Well, no, that's still a voluntary manslaughter, because they have an expectation if they throw a brick down onto cars that are traveling on the freeway, that type of activity could easily lead to somebody's death.
So something that's so extremely reckless.
Right, correct.
Like driving 90 miles an hour down University Avenue or something. That could be so reckless that that would be considered a voluntary manslaughter.
That is correct. Now, the involuntary manslaughter, there is literally no intent.
So let's say that involuntary manslaughter might be that maybe you did run a red light when you were going 25 miles an hour and you hit a pedestrian. So maybe you were doing something wrong at the time, but there was no intent to kill.
That is correct. Now, when the jury found the involuntary manslaughter, they did include an enhancement, which is a gun enhancement. That's going to be debatable whether or not that gets enforced. But with a gun enhancement, that could add an extra 10 years to his sentence, as well as make him do 85% of the time.
You know, what are we looking at for a involuntary manslaughter?
Well, an involuntary manslaughter can be 2 to 4 years, but on a first-time offense, it could be probation.
Okay, so we've got that. Now, what about affirmative defenses for an accusation like this, if you're a defendant or you're a defense lawyer? What would be some affirmative defenses?
Well, affirmative defenses would be the factors that the event was not, there was no premeditation, that the violence that's going on the platform all created an issue. But, you know, Mark, this subject we're going to have to revisit, because I really believe that we have to look at what the result was from this. What we have to understand is that although there's a lot of emotion in this crime, and there's a lot of emotion in this trial, the fact of the matter is a jury did hear the testimony, and the jury found the best they could under the rules that are provided in the court system. And tonight, we hope that these discussions have brought something to you at home, and we're hoping that you'll come back and visit us again for Law Talk. Mark, thank you so much tonight.
It's been a pleasure.
It's been an excellent show, and we all look forward to coming back again and enjoying.
Thanks.